Hello everyone, this is CS Padma Sharma. Welcome to Mathurya Edu. Today we are revising the next part of your constitution under CS Executive JIGL paper 1. We have already seen article 12, 13, 14, 15 and 16. Quickly revising, article 12 talks about your definition of state. And Ajay Hasya versus Khalid Mujib, the definition of state was extended. Article 13 talks about pre and post constitutional laws, how would be the validity of those laws. Article 14 talks about your fundamental rights, which is your right to equality, and everybody should be treated equally. But yes, you can make laws for women, for children, for scheduled castes, scheduled tribes, and these educationally backward people, economically backward people. Sorry. And Article 15 talks about that you should not be discriminated on the basis of your religion, race, caste, sex, place of birth, or any of them. And you should be allowed in access to all the shops, all the restaurants, all the public amusement parks, all bathing ghats, etc. Article 16 talks about no discrimination on terms of public employment based on the topics which was given above. But yes, your educational qualification, they can set those criteria. So for detail, you can check out the other video which I have uploaded. Now we are moving forward to your freedom of speech and expression, which is again one of the primary fundamental rights given to you under your Constitution of India. Now, freedom of speech and expression, I would like to start this particular video with one particular case which happened recently. Supreme Court in its there was this one NCERT chapter, social of standard 8, I guess. So Supreme Court directed the NCERT to remove that particular chapter. The chapter was talking about the role of judiciary in our society, and it somewhere mentioned that judiciary is also a part of corrupt practices, right? So judiciary said, the Supreme Court advised NCERT to remove that chapter, and then there's this one student of law, his name, if I'm not wrong, is Rishi Kumar, I guess. He has made this particular statement which said that our judiciary does not have any spine, because whatever was there in that particular chapter was the reality. And then it went on like a battle where court said him to remove his particular statement, and he said that no, he has right, he has freedom to speech and expression, he has right to keep his opinion. That is where he exercised his fundamental right and said that no, I am not going to remove that particular video, that particular statement which I have made, and I'm going to keep it. You give me the reasons why whatever I'm saying is not right. Why are you saying that this particular chapter should be removed from the NCERT book? Is this not the true reality of this particular country? Is this not the true state of what we are going through? So quickly taking with this thing, I'm going into the chapter which says freedom to speech and expression. Freedom to speak whatever is in your mind and to express whatever you're feeling, right? First, it said it guarantees the citizen, very important, it guarantees the citizen the right to make the speech, right? It is for the citizen to say whatever they feel like. Freedom of speech and expression, you have a right and freedom to assemble peacefully without arms. Without arms means without any weapons like gun, like bombs. You have right to assemble anywhere but without arms. Next, you have to form any association, union or cooperative society. If you want to have like a particular thing like association for sports, you have all the freedom to form that particular association and do your work. Move freely throughout the territory of India. You have the right, you have the freedom under Article 19 that you can move anywhere within the territory of India. Reside and settle in any part of the territory of India. Of course, when you are moving from here to there, other than if you are going for a travel purpose, you would want to settle there. And again, continuing, you can practice any profession or carry out any business, trade or occupation there. Fine. So this is your highlight, but yes, not everything comes as a silver spoon. You definitely have some restrictions imposed by the Constitution itself, that you cannot go against few things. Right? So the first thing says the restriction can be imposed by law and not by purely executive and order under the statute. So you need to have a proper law which is imposing those restrictions. Second, there must be some reasonable restriction. Don't give me some blunt thing that you cannot speak like this. Oh my God, like just because you're a woman you should have no voice. No, you are not supposed to make any blunt statement. You should have a predefined reason. Reasonable restriction are allowed. Fine. Restriction must be imposed for achieving one or more objective. It should be reasonable. Fine. First thing, Reasonable restriction connotes that a limitation imposed upon a person is to enjoyment of a right should not be arbitrary or excessive in nature. Now, your freedom, and when you're restricting, that should have some meaning why you're trying to restrict that particular thing. First, freedom, right to freedom of speech and expression, very important. The right to freedom of speech and expression include right to make a good or bad speech. Now, bad speech would be for the people against whom you are talking, right? If you're talking good about someone, it's a good speech. If you're talking not in their favor, then it automatically becomes a bad speech. But you have a right, you have a fundamental right to make a good or a bad speech. Now, this doesn't end here. You have more. You have a right not to speak also. In a lot of places, if you're going and they ask you any question, you have, and you would have seen they're saying no comments. Because this is also your fundamental right where you can say that I have right not to speak at all. Fine. So your freedom of speech and expression includes freedom to make good speech, freedom to make bad speech, freedom to no speech at all. Somebody is asking you something and I'm like, no comments. Now that means you're not making any speech. This is also your fundamental rights. Fine. One may express oneself by sign as well. We are not restricting ourselves with only this. Like for example, if someone is asking me anything and I just do thumbs up, right? So that means I'm agreeing to it. So this is just a sign. So you have right to express by sign language as well. Fine. The courts have held that the right includes the freedom of press to publish their opinion. For all the newspaper, they have given them this right that yes, you have right to make your opinion and publish your opinion in your papers as well. Right to circulate and propagate one's idea, freedom of peaceful demonstration, dramatic performance and cinematography. You see a lot of movies being made on certain incidents, social issues. So this is your right. This is your right to freedom of speech and expression to express what your opinion is. It can be in a cinematic way, it can be in a dramatic way, like you are holding some theatre dramas, or if you see earlier when they were prevalently in the newspaper, there will be one section of cartoons which will try to say some political condition, what is happening, or in a satire way there will be a few cartoons, right? So that is also your freedom of speech and expression. First thing, you have right to good speech, bad speech, no speech. Press have right to express their opinion. It can be dramatic way, it can be cinematic way, it can be through publication and circulation of their newspaper, and you also have right to express by sign language as well. Fine. Opinion freely by word of mouth can be done, writing can be done, printing can be done, pictures or any other mode can be done. Now prevalently we are doing everything in terms of social media, so that is also one of your medium where you are expressing your thoughts. Now permissible restriction, I can say whatever I want, but can I say whatever I want? No. There are certain reasonable restrictions, you have to understand that. Anything which is against the sovereignty and integrity of India, whatever, like any anti-national comments if you're making, that is not allowed. You can say that you don't like one particular political party or the way they are ruling, or some of their policies are not very fine. Talking against the government does not mean talking against the nation. There's a difference. That's why we are a democratic country. That's why we have election every 5 years, that if you're not liking any particular party, then you can go ahead and vote for some other party, right? So talking against the party doesn't mean you're talking against the nation. But talking against the party, is that a crime? No. But talking against the nation itself, will that come under your sovereignty and integrity of India? Yes. So you are, expected to have a certain sort of emotion for your nation, and you cannot make any of the statement which is going against your nation itself, which is affecting the integrity, the image of India. Fine. Next, security of the state. Your language or your way of saying or the statements which you are making is against the state itself, that is not allowed. Fine. Friendly relation with foreign state. You are making some comments where we have a good relationship with some other country, some international trade or international policies or treaties which is affecting that. You cannot make those statements. You are not allowed to make those statements. Public order. If you are making anything which is against the public order, which is a bit offensive for the other people, you are not allowed to do that. Decency and morality. That's why we say when you are in public, don't behave very indifferently, or don't make any kind of statement which could affect the public. So for decency and morality also, you cannot make any statement. Contempt of court means insult of court itself. You cannot do that, right? Again, this is where the Rishi's topic was debate, that you are contempting the court, you are insulting the court itself, where he said that if you can prove me wrong that judiciary is not corrupt at all, then prove it. right? This is where he said that I'm not making any contempt of code, but then this is based on my experience, this is based on my research, my observation, and then I'm making this particular statement, right? Defamation itself is another thing. Defamation means you're trying to insult, you're trying to tarnish someone's image. That is again not allowed. Defamation, you can file a defamation case itself if this is, you know, false, somebody is trying to, you know, tarnish your image, so you can go ahead and file a case against them itself. So defamation is again not allowed. And incitement of an offense, any kind of statement under your freedom of speech and expression you are making which can have any, which can give birth to any offense, that is also not allowed, right? Next, you have freedom to assemble anywhere but without arms, that is without any weapon you can assemble anywhere. But again, sovereignty and integrity of India, you're forming an you're assembling at a place, and then you are making a statement which is against the nation, right? We have seen few cases in the past in Delhi, mostly most of the things happen come out from Delhi. So yes, they assemble, but they were talking which was against the nation, and a lot of people were arrested at that time. So you can assemble anywhere peacefully but without arms, and again there should be no effect, it should not affect the sovereignty and integrity of India and public order. Then you have freedom of association. If you want to form any association for trade, association for particular religion, association for any particular sports, you are free to form that. So freedom to hold a meeting and to take out procession without arms. Again, when you're going for any rally or, you know, political rallies are happening, you can assemble there but peacefully without arms. Right to form association or union is also guaranteed, so that people have freedom to entertain similar views. Again, sovereignty and integrity of India, public order and morality, against them you cannot go. You have to always make sure that you are under this purview. Freedom of movement throughout the territory of India, wherever you want to go, wherever in any other state if you want to go, you can move there within the territory of India, is your fundamental right. Is another right guaranteed under Article 9(1)(d). However, it does not extend to travel abroad. It does not extend to travel abroad. Now let's take hypothetically this example. People have committed a crime and they want to run away from this country, and if this was a fundamental right, and if the government tried to stop them, that no, you have looted public and you cannot go out, that person can say that no, I have fundamental right to travel abroad as well, so I'm leaving this country. It doesn't matter that I've committed any fraud or not. Now this will become a problem. That is when they are saying that no, throughout the territory of India, the government will have their power. So yes, there you can move, but to travel abroad is not a fundamental right at all. Fine. And like other rights stated above, it is also subject to reasonable restriction. One, for the interest of the general public. That's why you take a lot of permission before you are trying any going for any rally. And next, for the protection of any scheduled tribe. There were a lot of movies, like one of this was like this. What was that movie? Kantara, which was based on one particular tribe. Now to protect them, can they make a restriction that, you know, you should not enter this particular place, and restricted that, you know, if you're going there you have to go certain way only? Can they do that? Yes. For protection of their interest, they can go ahead and government can make laws for that particular thing. Fine. Freedom to reside anywhere. If you're moving anywhere and if you want to settle any part, like from North India, you're coming to South India, or you're moving vice versa anywhere, you have all the right to settle anywhere within the territory of India. Right to reside and settle in any part of territory of India, and then intended to remove internal barriers within the territory of India to enable every citizen to travel freely and settle down in any part or state or union territory. Fine. Then you have freedom to trade and occupation. Yes, whatever trade you want to do, whatever occupation you want to carry on, you can do that. All citizens shall have right to practice any profession or to carry on any occupation, trade or business. But yes, if you want to have any technical qualification, like to become a doctor, you'll have to pass certain exam. To become an IAS officer, you have to pass certain exam. To become engineer or any person, then you have to pass certain exam. Then definitely you have to follow that. Other than that, you have all the right to practice whatever profession you want to practice. Right? Reasonable restriction should be there. Professional and technical qualification can be one of the restriction, and any trade or business to the exclusion of private citizen, that can also be given to them. But few things which are given only for the government to do, like the defense, nuclear development, all these things are reserved for the government to do. Other than that, whatever you want to do, you can carry on and do that particular business. Fine. Next we have your Article 20, 21 and 22. Article 20 talks about ex post facto laws. Fine. Let's take for an example. I did something here, okay. I did something in 2000. I did something in 2010. Then in 2012 there was one law which said whatever this particular thing is, now this will become a crime. Can you go ahead in 2010 that, oh, you did this particular crime in 2010? No, now I'm going to arrest you because in 2013 we are today. So in 2013 if you see, this is a crime. No, they said if you are making retrospective law, then you have to, like, from what time are you going to calculate, right? So this doesn't make sense. That's why we have ex post facto laws, which says ex post facto laws are laws which punished what had been lawful when done. When you have done it, at that time this was not called as a crime, so it was lawful when you were actually doing it. So in 2010 it was not even a crime, so I did that at that time, fine. But in 2012 you made a law and then you made it an offense. After that, if I'm doing anything, of course that's a crime. Before that, if I'm doing, it was a lawful activity, fine. If a particular act was not an offense according to law of the land at the time when the person did that, then he cannot be convicted under a law with the retrospective declaration. This is your ex post facto law. Then you have protection against double jeopardy. Double jeopardy is nothing but, punishing one person again and again. If a person has committed any offense or crime and you have punished him once, that's it. It ends there. You cannot again and again be like, I think I'm not satisfied with the right I have given to, with the punishment I gave him. I think I need to go ahead and give him 2 more years of imprisonment. Can you do that? No, you cannot punish one person more than once, right? No person can be prosecuted and punished for the same offense more than once. You can only once be prosecuted and punished. Protection against self-incrimination. Self-incrimination means I'm saying something against myself. So I have protection against self-incrimination. Something to say against myself, I can protect myself against it. Like, I'm in a court, I've been called as, someone who has committed any crime, and the court asks, did you do that? And I'm not saying anything. I'm saying it's my fundamental right, protection against self-incrimination, because whatever I can say, that can go against me itself. So I'm not saying anything only. Can you do that? Yes. Fine. No person accused of any offense shall be compelled to be a witness against himself. He cannot be compelled to be a witness against himself, but yes, to make that person, first he must be an accused of an offense. There must be a compulsion to be a witness, and such compulsion should result in giving evidence against himself. So 3 things you have to, there must be an offense, you should be forced to give that, and then it will result in giving evidence against yourself. So you can invoke this particular article, which is your article 20, which says protection against self-incrimination. Now next you have very well article and very well your fundamental right, which is protection of life and personal liberty, which is your article 21. Very important. Let's discuss Harish Rana case again. Now here, when the court came and said passive euthanasia, I want to do that, they said right to life, protection of life and personal liberty include right to die with dignity as well. If I want to go ahead and die because that person was in coma for last 13 years and on life support, on medical support, so court said that he has right to live, but we see no result in him, and we don't see him coming into his normal form anytime soon. So he has a right to die peacefully as well, to die with dignity, right? So no person shall be deprived of his life or personal liberty except according to the procedure established by law. But yes, you have a procedure established by law. The right of life includes those things which can make life meaningful. It does not mean like, my life is just like this. No. To make your life meaningful, if you want to do something, you can do. For example, to adopt a kid. If that is making your life meaningful, you can go ahead and adopt a kid as well. In constitutional right guaranteed under Article 21. Right to life, right to live with dignity was also mentioned here. Right to live in freedom from noise pollution is also your fundamental right protected under Article 21. That is why you cannot, play music after 10 p.m. These are certain restrictions. You see here, procedure established by law. These are certain procedures that we have established that yes, you can enjoy. That is your life. That is your liberty. If you want to go ahead to party, dance, everything is fine. But there's a procedure established by law. You are not disturbing anybody. You have to make sure of that particular thing, right? And noise pollution beyond permissible limits enrolled into that right. Now this is very important case law again, A.K. Gopalan versus State of Madras. In this case, they have given a very narrow meaning to your personal liberty. They said that personal liberty only means body of a person. Whatever I want to do with my body, wear whatever I want, do my makeup or not do my makeup, that is what your right to life means, right? So this was a very narrow meaning, but later in Kharak Singh versus State of Uttar Pradesh, they changed it and they said that it is beyond that. It's not only your personal, bodily work that you have to do, but apart from that also few things. Now in this case, what happened, there was a police officer who used to knock on Kharak Singh's doors even in midnight for some inspection and investigation, and Kharak Singh was so much disturbed with this, and he's like, I cannot even sleep peacefully. What about my right and my freedom and protection of life and liberty? So the court said, yes, you have some certain time frame within which you can go and investigate. So if you are going beyond that, you are disturbing their life. To sleep is also like sleep is your medicine, right? So in that way, you are disturbing him and you are not allowed to go and do that, fine. Question raised was the validity of the police regulations authorizing the police to conduct what are called as domiciliary visit against bad characters and to have surveillance over them. The court said, no, you cannot go and visit them beyond the hours. In Menaka Gandhi versus Union of India, again one of the important case, personal liberty within the meaning of Article 21 includes within its ambit right to go abroad. Right to go abroad. But we said that we cannot give this as a fundamental right. No. Yes. But read again. And no person can be deprived of his right except according to the procedure established by law. You can go abroad, you can travel if you want to go. That is again personal liberty. I can feel like the air quality is not good here and I want to go out and breathe well, breathe fresh, breathe natural air. Can I go and do that? Yes. Procedure established by law, which is go for visa proceedings, go for interviews, those things are there and you have to go do that and then you can carry on, fine. Presently, the term personal liberty extends to a variety of matters like right to bail is also your personal right. Right not to be handcuffed is also your right. If some person is saying, I'll walk with you, don't handcuff me because I want to live with certain dignity, that is also your right to your personal liberty. Fine. Next we have Article 21A, which is right to education. Everybody has right to education, but all children from the age of 6 to 14 has right to education. Primarily they should be educated. Fine. Qualified teachers and basic infrastructure should be there. Qualified teachers, it's not. I've seen a lot of videos on social media where teachers don't even have basic qualification to be teaching to the students of 6 to 14 years, but yes, they are there. You should always be vocal and raise question on these particular topics. So qualified teachers also should be there, and basic infrastructure should be there when you are taking them. Then child should not be restricted only to freedom and compulsory education, but should be extended to have quality education without any discrimination on the grounds of their economic, social, cultural background. It should be extended that you come from certain background, I am not going to allow them. That should not be there. Right? Right to internet access also. If you see, this case came in 2019 only, very recent case. They said right to internet access also one of your fundamental rights for your education, because now everything we do is ChatGPT. Anything, any problem, any situation we are facing, we go to ChatGPT, right? So right to internet access, but it would be suggested that you can do your research with books, but this is your fundamental rights under Article 21A. Then you have protection against arrest and detention. Again, this is one of the most important topics. This has been asked again and again in your paper. So please understand this thing very clearly. First, you cannot be detained in custody unless he is informed as soon as he may be on the grounds which he is arrested. If you're arresting me, tell me the reason why you are arresting me. You cannot just tell me, come to the police station, I'm going to put you in jail. Why are you putting me in jail? Important. You should be aware of why are you getting arrested. Grounds should be informed. Second, you have right to consult and have a defense law, like a law practitioner who can represent you in the court. That is again your fundamental rights. And he should be presented before your nearest magistrate within 24 hours of arrest, excluding the time of journey. So if they have arrested you from your house to the police station, so when they have arrested you, from there 24 hours they have to produce you to the nearest magistrate, excluding the time of journey whichever they would be taking to take you to the magistrate. That would be excluded. So first thing, they should give you the grounds. First thing, they should give you the grounds which you are for which you are getting arrested. Second, consultant, you should have right to consult anybody, that is your lawyers. Third, you should be taken to the nearest magistrate within 24 hours except excluding the time of journey. Now, preventive detention, this is also one of the important topic. Preventive detention, the word itself says I'm preventing something, that's why I'm detaining you. Preventive detention, you have not committed any crime, but you are likely to commit any crime. If you're roaming outside, you might commit a crime, that is why we are arresting you. So detention of a person without a trial, the object of preventive detention is not to punish a person for having done something, but to prevent him from doing it. You haven't done anything as of now, but you might do, that's why we are keeping you inside, right? No offense is proved nor any charge formulated, and yet a person is detained because he is likely to act likely to do certain act which is prohibited by law. Again, in this, you cannot keep a person in your custody more than 3 months. If you are arresting anyone, as part of your preventive detention, then you can only keep him for 3 months. Now, forget about preventive detention. If you are only arrested, right against your arrest, then first thing, you should be given your grounds for which you are getting arrested. Second, you should have right to consult, that is your lawyer. And then you should be presented before the magistrate within 24 hours, excluding the time of journey. These are your 3 points against your arrest. Now, preventive detention says that you have not committed any crime, but you are likely to commit any crime. That's why I'm arresting you, right? So this is done, but I cannot keep you in custody for more than 3 months unless, important, unless a committee is formed and the advisory committee has sufficient cause and opinion that you should not be let out. Even after 3 months, you should be in the custody, then you can remain in the custody. Parliament may pass law prescribing the maximum period. Now, for everything, Parliament has the right, because residuary power is with the Parliament, so they have the right to pass any law which would describe the time. And the authority for detention of person under the preventive detention law shall communicate to him as soon as the grounds are there. If I'm extending beyond 3 months, then again I have to go and communicate him the grounds. And earliest opportunity of making representation. Again, we are coming to this point again. If I'm extending my more than 3 months thing, then I should be given grounds and consult a lawyer, consult a legal practitioner who can go and represent me. That is your Article 21. Article 21 and 22. Right? Next we have quickly only this one, which is your right against exploitation. This is also your fundamental rights, right against exploitation, which says prohibition of traffic in human beings and forced labor. The most thing I could think right now about these are the Epstein files. Now this is a crime against the law of humanity itself, but nothing has been done in that particular case, so we don't know where this is going. But yes, in India, at least as per the books, we have this fundamental rights which prohibits the trafficking in human beings and forced labor. Trafficking in human beings means selling their organs. A lot of people donate their organs once they die. They'll be like, donate my eyes, donate my kidney, donate my heart. So this is their own will to do it, that they can do. But yes, if you are trafficking human being for like a lot of things, for your organ trading as a sex racket, you can do that. You are trading women, you're trading children, you're trading minors, a lot of things like that, then it is not allowed. This is your right against exploitation. So Article 23 imposes complete ban on trafficking of human beings, beggar and other similar form of forced labor. If someone has appointed you, then they have to give you certain amount, right? Any labor without payment or even laborer with payment against their desire can compel against the violation of a fundamental right under your Article 23. Deal in men and women like goods, such as sell or let otherwise dispose them of beggar means involuntary work without payment. This is exploitation. This cannot be done. The state can impose compulsory service for public purpose, such as conspiration of defense or social service, etc. While imposing such compulsory services, the state cannot make any discrimination on the grounds only of religion, race, caste, or any class of them. right? Prohibition of employment of children below the age of 14. Now if you connect this with this, education, because till the age of 14 we are saying you should have right to education. Only after that you should be in a position to go and work as a employee in any employment. So prohibition of employment of children below the age of 14 in any factory or mine is not allowed. The Employment of Children Act under Employment of Children Act 1938. That's it with your fundamental rights under your Constitution of India. And in the next video I'll cover the remedies under this, which you have 5 writs. Thank you so much.